Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. McEwer is back in court, and this time he's learning the hard way why having an attorney actually matters. If you're new here, this is part 2 of Situation we covered a little while ago. Daniel McEwer came in with the same attitude as before, refusing to directly answer Judge Simpson's questions and carry himself like the rules simply don't apply to him. He has that smug, know-it-all energy that immediately puts the courtroom on edge, and it did not take long for things to start going downhill. From the jump, it was rough. He's standing there, without any legal representation, casually chewing gum in front of the judge like he's hanging out somewhere instead of facing serious consequences. That alone tells you everything about how he's approaching this. Let this be a reminder. If you're ever in a situation like this, get proper legal counsel. Don't follow the path he's choosing here. But enough setup. Let's dive in and see how today's exchange between McEwer and Judge Simpson unfolds.
And so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing.
You wish to have a preliminary examination?
Preliminary examination.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, with no hearing date scheduled. So I'm hoping that to sort of reconcile both of those things as whether or not discovery is complete, the defendant is prepared to move forward, and if he ever file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So it was improper for the wording, Your Honor. I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam. We'll
Thank you, Your Honor.
deal with it at that point in time. So the people would have their witnesses available on the second.
We could try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12 noon, that is before me.
Thank you, Your Honor.
And continue.
This situation is a perfect example of why representing yourself in court can backfire fast. Not only did he refuse to get legal help, but he also tried to outmaneuver the judge with this overconfident, dismissive attitude. It's honestly hard to understand why he thought that strategy would work. If you watch similar cases, you probably noticed the same tone before, almost like the sovereign citizen mindset, where someone talks down to the court as if they're above the system. That same exaggerated confidence shows up here, and it never ends well. Meanwhile, the charges he's facing are extremely serious, including allegations of assaulting a police officer, and the consequences have already impacted his life in major ways, including custody issues involving his child. Situations like that don't happen over something minor. Yet he walks into court acting like it's no big deal, brushing everything off as if denial alone will fix it, instead of helping himself. He keeps making things worse and pushing the judge's patience to the limit. Watching it play out, you can see how damaging self-representation can be when someone isn't prepared or willing to follow procedure. At the end of the day, this clip is another reminder that confidence without strategy is not a defense. I'll be covering the next hearing when it happens, and based on how this one went, it's bound to be intense. If you found this breakdown insightful, showing support with a like and subscription truly helps. Thanks for watching, and as always, take care.